Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Criminal defense lawyer in Chicago. A criminal charge in Chicago shouldn't ruin your life. Combs Waterkotte's Chicago criminal defense lawyers have more than 8 decades of combined experience handling Cook County felony and misdemeanor charges. We fight aggressively to protect your rights, scrutinize the prosecution's evidence, and build you the best criminal defense you can get. Every case review starts with a free consultation, and we offer customized payment plans so you never have to choose between your finances and your freedom. Trusted Chicago, Illinois criminal defense lawyers. When you're facing criminal charges in Chicago and Cook County, Illinois, you have constitutional protections under the law that you can use to fight back. Using those rights and navigating the Illinois court system without a defense attorney, though, is impossible for everyday, hardworking people. That's why you need a skilled Chicago criminal attorney in your corner to stand with you every step of the way. At Combs Waterkotte, we help Chicago residents like you who are facing life-altering criminal charges every day. Our award-winning criminal defense firm has over 80 years of combined experience, and we've successfully handled over 10,000 cases. If you're ready to fight your charges head-on with the help of a team who sees you as a real person and not just a number in a case file, call 312-500-HELP today. We'll get you through your legal situation together. A full Chicago criminal defense team to support you. When you hire Combs Waterkotte to handle your Chicago area criminal charges, you gain access to a full team of criminal attorneys, paralegals, and law clerks who work together on your case. Our trial-ready attorneys and our friendly, client-focused support staff are all dedicated helping you. Protect your legal rights. Navigate your way through your criminal charges. Make informed decisions about your legal defense. Earn the best possible resolution to your criminal case. Chicago Criminal Defense Attorney. Best criminal lawyer in Chicago, Illinois. Our firm has successfully defended thousands of clients throughout Chicago and Illinois, providing criminal defense for everything from misdemeanors to serious felonies. Whether you've been charged or arrested for assault, DUI, theft, drug crimes, sex offenses, or complicated federal charges, we're here to guide you through it all and fight for you the whole way. We win the cases other Cook County firms call unwinnable, and we're ready to defend you against any type or level of criminal charge in Illinois. How our Chicago, Illinois criminal defense attorneys help you. Just because you've been charged with a crime in Cook County or Chicago doesn't mean you'll be convicted. With quick intervention and the use of proven criminal defense strategies, Combs Waterkotte can intervene at every step of the process, from the initial investigation of your alleged criminal activity all the way through to the conclusion of your case. Pre-charge protection. While you're under investigation, we can intervene before prosecutors file charges. We'll be present with you during police interrogations, protecting your rights and pushing for the reduction or dismissal of your charges. Warrants and new court dates. If a warrant has been issued for your arrest, we can work to get it quashed or recalled. We can also get you back on the court's calendar without you having to endure another arrest. Bail and bond. If you are charged, we can seek release on recognizance or bond reductions, argue for reasonable release conditions, and request modifications, work, travel, school, and the removal of any unnecessary monitoring. Suppress illegally obtained evidence. We'll examine every aspect of the police investigation into your charges, challenging vehicle stops, searches, and seizures, and any statements you made. If we don't like what we find, we'll file motions to suppress and exclude any evidence law enforcement obtained while violating your rights. Motion to reduce or dismiss. Before a court date even arrives, we'll attack probable cause, prosecutorial charging defects, overcharging, and charge enhancements to pursue dismissals or lesser criminal counts. Pressure for discovery evidence. We'll take on prosecution teams, demanding to see all of the evidence against you, enforcing deadlines, and sanctioning late evidentiary disclosures so you aren't ambushed. Independent investigations. Our team will conduct witness interviews, retain private investigators, secure surveillance or body cam footage, and issue subpoenas. We'll use all of this evidence to develop an alibi defense for you when we can. Forensics and lab challenges. We'll scrutinize every bit of forensic evidence against you, calling for retests when appropriate, and looking for chain of custody inconsistencies, evidence contamination risks, and weaknesses in testing methodologies. If we need to, we'll even cross-examine laboratory personnel. Digital evidence review. Our knowledgeable team has the capacity to analyze the digital evidence against you, including phone downloads, social media data, GPS, and video files. We'll move to limit or dismiss unreliable or prejudicial material where we can. Strategic negotiations. If the prosecution's case is lacking, we'll leverage that weakness to negotiate for charge reductions, deferred dispositions, or dismissals, but only when it benefits you. Diversion and alternatives. In cases where they apply, we can pursue diversion, treatment courts, community service, classes, and other outcomes that help to avoid jail or prison and protect your criminal record. Collateral consequence planning. We can help you to plan for the effects your case may have on your employment, professional licenses, housing, firearms, and immigration status. If we need to, we can coordinate with outside counsel. Probation and parole help. Our team can help defend you against alleged parole or probation violations, argue for alternatives to revocation, seek an early discharge, and adjust your conditions so you can keep working and caring for your family. Protective orders crossover. We can help defend you against orders of protection and other related contempt issues that may have an impact on your criminal case. Asset forfeiture defense. If your money or property was seized during a police investigation, we can contest those seizures and negotiate the return of your assets with the state. Trial ready from day one. Throughout it all, we'll stay prepared for motions in limine, jury selection strategy, and witness examinations so you're positioned to win if we decide together that going to trial is our best path forward. Criminal defense. Know your rights in Chicago, Illinois. While being arrested or investigated by law enforcement officers in Cook County or Chicago can be intimidating, it's important to know that police must follow strict procedures while interacting with suspects. You have rights, and our criminal attorneys ensure police follow them to the letter. Police officers tend to do whatever they have to in order to arrest and book someone, even if that person is completely innocent. In fact, police are allowed to lie to you in pursuit of an arrest or conviction. A Combs Waterkotte criminal lawyer will ensure Chicago police do not violate your Fourth Amendment right against illegal search and seizure, your Fifth Amendment right against self-incrimination, your Sixth Amendment right to a lawyer, your Miranda rights if placed under arrest. Illinois criminal law is incredibly complex. There are so many technical terms and so much legal jargon that it can be confusing to tell what you've even been charged with. In some cases, it's best just to negotiate with the prosecution to avoid criminal charges on your record. Every case is different, though, and it's tough to know what you should do in your situation without legal advice. Whatever charge you're facing in the Chicago area, reach out to Combs Waterkotte at 3125-00-HELP or contact us online. We'll work with you to help you achieve the best outcome possible. Still on the fence? Read about why you should choose Combs Waterkotte to help defend you against your Cook County and Chicago, Illinois criminal charges. Charges our Chicago criminal defense lawyers fight against. If you've been arrested or charged with a crime in Chicago, Illinois, you need a criminal attorney with experience practicing in Illinois. At Combs Waterkotte, we've successfully defended clients in Chicago and Cook County against a wide range of criminal charges, from weapons crimes and sex offenses to domestic violence and drug crimes. Don't let a conviction ruin your freedom, your career, or your future. Let our skilled legal team fight aggressively to protect your rights and achieve the best possible outcome in your case. Felony defense attorney in Chicago, Illinois. Being convicted of a felony offense in Chicago, Illinois can have an effect on your life that lasts for years to come. Under Illinois law, felony offenses are classified in certain categories based on the severity of the offense in question. Illinois felonies range from Class 4 felony crimes like retail theft and possession of small amounts of controlled substances to Class 10 felonies like armed violence or rape. The sentencing and punishments for felonies in Illinois depend on what class of felony you're facing. You could be up against long prison sentences, substantial fines, or a years-long period of probation. You could also face collateral consequences like employment barriers, housing issues, or the loss of firearm rights. Class 10 felony, 6 to 30 years in prison, or 30 to 60 years for an extended term. Class 1 felony, 4 to 15 years in prison, or 15 to 30 years for an extended term. Class 2 felony, 3 to 7 years in prison, or 7 to 14 years for an extended term. Class 3 felony, 2 to 5 years in prison, or 5 to 10 years for an extended term. Class 4 felony, 1 to 3 years in prison, or 3 to 6 years for an extended term. Learn more about the long-term consequences of an Illinois felony conviction here. Violent Crimes Lawyer, Chicago, Illinois. Combs Waterkotte's Chicago Violent Crimes Lawyers are no stranger to guiding clients facing some of the most serious criminal accusations under Illinois law. Violent crime offenses in Chicago carry potentially severe consequences. Long prison terms, large fines, collateral consequences like custody problems and professional licensing issues, and a permanent criminal record. A conviction can follow you for the rest of your life. Depending on the specifics of the case, the consequences of a Cook County violent crime charge may range from low-level misdemeanors to Class X felonies, punishable by decades in prison. Prosecutors tend to pursue convictions in violent criminal cases aggressively, which means you need a defense team with the experience and resources to take them on. Some of the most common violent crimes we defend against in the Chicago and Cook County area include first-degree murder, unlettered felony with mandatory prison term of 20 to 60 years, and potentially a life sentence. Second-degree murder, Class 1 felony with sentences ranging from 4 to 20 years. Manslaughter, voluntary and involuntary. Felony charges with 3 to 15 years in prison, depending on the circumstances. Assault and aggravated assault. Misdemeanor to felony charges with penalties, including long prison sentences and high fines. battery and aggravated battery, Class A misdemeanor to Class X felony, depending on the circumstances with long prison stints possible. Kidnapping, Class 2 or Class 10 felony, if ransom is demanded, with lengthy prison sentences typical. Other violent offenses, including carjacking, child abuse, and unlawful use of a weapon, each carrying felony-level penalties. Our Chicago, Illinois violent crimes defense lawyers can establish a solid criminal defense for you, no matter your charge. We'll thoroughly examine police reports, witness statements, and forensic evidence to develop a defense strategy built around lack of intent, self-defense, or defense of others. If we have to go to trial, we're prepared to fight for an acquittal to minimize the effect your violent crime charge has on your future. Domestic violence lawyers, Chicago, Illinois. Typically emotionally charged, domestic violence cases in Chicago involve a lot of layers. They often come with felony-level penalties and may result in custody problems or orders of protection. It's important not to get into a battle of he said, she said in a domestic violence-related case. Instead, it's essentially to let an attorney handle your case. Our Chicago domestic violence lawyers handle these types of cases all over the Chicago and Cook County area. Not only do we have a deep understanding of domestic case law in Illinois, but we've also developed defense strategies to help ensure any of our clients facing a domestic violence charge achieve the best outcome possible in their case. Some common domestic violence charges and related offenses in Chicago include domestic battery, charged as a Class A misdemeanor, but enhanceable up to a Class 2 felony for repeated offenses. Aggravated domestic battery, domestic battery that results in great bodily harm, a Class 2 felony with up to 7 years in prison. Child abuse, charged as a Class A misdemeanor, but enhanceable to a Class X felony for particularly heinous offenses. Child neglect, months in jail for a first-time offense, up to 10 years in prison for aggravated or fatal neglect. Violation of an order of protection. Typically a Class A misdemeanor, but enhanceable to a felony for repeated or aggravated offenses. Stalking and aggravated stalking, a felony offense that could result in 1 to 7 years in prison, depending on the circumstances. Learn more about the defenses to a domestic violence charge in Illinois here. Gun crime lawyer, Chicago, Illinois. Illinois has some of the most strict gun laws on the books in the United States. For this reason, if you're facing a weapons charge in Chicago or Cook County, it's vital to enlist the help of a criminal defense attorney as soon as you can. Combs Waterkotte's weapons crimes lawyers are deeply familiar with Illinois' gun charges. We've helped clients in Chicago and the surrounding areas avoid prison time by getting their weapons charges reduced or dismissed. Here are some of the most common gun crimes we help defend against throughout the city of Chicago. Aggravated assault, charged as a Class 4 felony for brandishing a weapon at a police officer or firefighter, resulting in a years-long prison sentence. Unlawful use of a weapon. Applies when in possession of brass knuckles, a switchblade knife, or a pistol or revolver without a firearm owner's ID, FOID, card. Aggravated unlawful use of a weapon, charged when carrying a loaded, immediately accessible firearm outside of a case without a FOID card, potentially resulting in decades in prison, depending on the circumstances. Armed habitual criminal, Class 10 felony offense, charged when selling or possessing a firearm after 2 or more previous felony convictions. Aggravated vehicular hijacking includes a Class X felony with years in prison for stealing a car while using a deadly weapon. Armed violence, a Class X felony charged while committing another felony while armed with a handgun, machine gun, or sawed-off shotgun. Sex crimes lawyer, Chicago, Illinois. Sex crimes in Chicago and Cook County. Illinois carries some of the harshest penalties under Illinois law. Prosecutors in the greater Chicago area take these charges very seriously, often moving aggressively to secure a conviction. Even just the accusation of a sexual offense can have a dramatic impact on your personal life and career. Sex offense cases are very technical, involving complex issues around consent, forensic evidence, and police procedures. At Combs Waterkotte, our sex crimes lawyers understand the severity and sensitivity of these kinds of charges. We've defended hundreds of clients in the Chicago area against sex offense allegations, challenging unreliable witness testimony, false and exaggerated claims, and the handling of forensic evidence. If you're facing a sex crime charge in Illinois, we can help. The following are some of sex crimes we defend against in Cook County and Chicago. Criminal sexual assault. Essentially, Chicago's rape law. Class 1 or Class 10 felony, with possible prison sentences from 4 to 60 years. Aggravated criminal sexual assault. Class 10 felony, with 10 to 25 years of added prison time for using a weapon during the assault. Criminal sexual abuse. Sexual contact performed without consent. Class A misdemeanor to Class 2 felony, depending on the circumstances. Aggravated criminal sexual abuse. Sexual abuse against minor or vulnerable victims. Class 2 or Class 1 felony with up to 15 years in prison. Predatory criminal sexual assault of a child. Class X felony with major enhancements for weapons or drug involvement. Life sentences are not uncommon. Learn more about sex crimes for which you must register as a sex offender in Illinois. Drug charges lawyer, Chicago, Illinois. The Illinois Controlled Substances Act outlines a wide range of penalties for drug offenses in Chicago. From possession of drug paraphernalia to high-level drug trafficking offenses, penalties range anywhere from low-level misdemeanors with likely probation to Class X felony offenses with decades-long mandatory prison sentences. Whatever the charge, if you've been arrested for a drug crime in the Cook County area, you need a criminal defense attorney who understands Illinois' deeply complex drug laws and has experience defending clients in drug-related cases in Chicago courts. A Combs Waterkotte drug charges lawyer can help you achieve the best possible outcome in your case. Here are some of the most common Chicago drug charges we help defend against. Possession of a controlled substance. Low-level misdemeanor to high-level felony, depending on the substance and the amount. Heroin, cocaine, morphine, LSD. Manufacture or delivery of a controlled substance. Felony-level offense with years-long prison sentences and six-figure fines. Possession with intent to distribute. Felony offense. Intent to distribute is inferred based on possession of high-level amounts of controlled substances. Drug trafficking. Class 3 to Class 10 felony, with certain convictions resulting in mandatory prison sentences as long as 60 years. Drug conspiracy. Low-level misdemeanor to high-level felony, depending on the substance, success, the extent of the conspiracy, and whether gang activity is involved. Methamphetamine possession and delivery. Felony offenses, 2 to 15 years in prison for possession, and 4 to 30 years in prison for delivery. Cannabis trafficking, for trafficking 2,500 grams or more of cannabis. Class 1 felony for 2,500 to 5,000 grams. Class 10 felony for 5,000 grams or more. Learn more about the penalties for drug possession in Illinois here. DUI lawyer, Chicago, Illinois. Combs Waterkotte's Chicago DU. I lawyers have helped plenty of Cook County. Illinois residents navigate their driving under the influence charges. Illinois takes impaired driving offenses very seriously. Even a first-time offender can lose their license, pay high fines, and even face jail time, depending on the factors involved in the charge. The penalties get harsher with each subsequent conviction, climbing from a misdemeanor to a high-level felony charge. Illinois law's penalties for DUI convictions are as follows, from least to most severe. First, DUI, with BAC greater than or equal to .08 or drugs, Class A misdemeanor with up to 364 days in jail and a fine up to $2,500. First DUI, with BAC greater than or equal to .16, Class A misdemeanor with up to 364 days in jail and a fine up to $2,500. Mandatory minimum 100 hours of community service and a $500 fine. First DUI, with a child passenger under 16 years old. Class A misdemeanor with up to 364 days in jail and a fine up to $2,500. Mandatory $1,000 fine and 25 days of community service. Second DUI, Class A misdemeanor with up to 364 days in jail and a fine up to $2,500. Mandatory minimum of 5 days in jail or 240 hours of community service. Second DUI, with BAC greater than or equal to .16, Class A misdemeanor with up to 364 days in jail and a fine up to $2,500. Mandatory minimum of 2 days in jail and a $1,250 fine. Aggravated DUI, driving with suspended/revoked license, unlicensed or uninsured, Class 4 felony with up to 1 to 3 years in prison and a fine up to $25,000. Applies even for first-time offenses. Aggravated DUI, third DUI, Class 2 felony with up to 3 to 7 years in prison and a fine up to $25,000. Enhanced penalties for offenders with BAC greater than or equal to .16, $2,500 minimum fine, or child passengers, $25,000 mandatory fine. Aggravated DUI, fourth DUI, Class 2 felony with up to 3 to 7 years in prison and a fine up to $25,000. No probation permitted. Minimum fine of $5,000. DUI causing great bodily harm or permanent disability. Class 4 felony with 1 to 12 years in prison and a fine up to $25,000. DUI causing death. Class 2 felony with up to 3 to 14 years in prison for 1 death or 6 to 28 years in prison for multiple deaths and a fine up to $25,000. Fifth DUI, Class 1 felony with up to 4 to 15 years in prison and a fine up to $25,000. No probation permitted. Minimum fine of $5,000. Sixth and subsequent DUI, Class X felony with up to 6 to 30 years in prison and a fine up to $25,000. Mandatory prison sentence and a minimum fine of $5,000. Combs Waterkotte's DUI defense lawyers won't simply accept the court's version of events and pressure you into taking a plea deal while collecting a fee. Our DUI defense approach starts with an in-depth review of your police report and all the available evidence against you. And, while a conviction may seem certain, the facts of the case may say otherwise. Chicago and Cook County police officers are required by law to follow specific procedures when pulling someone over and/or arresting them for DUI. If they violate their procedures even slightly or improperly administer field sobriety tests, that may be enough to get your case dismissed. We examine every aspect of your DUI case, scrutinizing breath and blood tests, traffic stops, and field sobriety tests for procedural or testing errors. Our lawyers regularly succeed in getting Chicago DUI charges reduced or dismissed, negotiating for alternative treatment or diversion programs. We're also ready to take your case to trial if we have to, and win there. We'll also help you to deal with statutory summary suspensions, the process through which the state of Illinois attempts to suspend your driver's license. Our goal is to keep your license intact and keep you out of prison. We've helped residents all over Cook County through their DUI case, and we're prepared to help you, too. Learn about what you should do if you're pulled over for a DUI in Illinois. Theft and Property Criminals Lawyer, Chicago, Illinois. Theft and property crimes in the Chicago area carry penalties from low-level misdemeanors for first-time offenders to high-level felonies for offenses like armed home burglary. If you've been arrested or charged for a theft or property crime in Cook County, you need a good criminal defense lawyer on your side. Combs Waterkotte's theft lawyers in Chicago can help you fight back against these charges, challenging evidence and negotiating for reduced or dismissed sentences when the prosecution's case is weak. Common theft and property charges we help to defend against in Chicago include retail theft, generally a Class A misdemeanor with probation or short jail sentences, Class 2 felony with multiple years in prison for repeat violations, burglary, Class 2 felony charge, Class 1 felony if the targeted location is a church or a school, Class 10 felony if the offender is armed, residential burglary, Class 1 felony with a 4 to 15-year prison sentence and a possible fine up to $25,000. Aggravated burglary. Burglary offenses where offender is armed. Class 10 felony with up to 30 years in prison. Possession of a stolen vehicle. Class 2 felony offense with a prison sentence between 3 and 7 years. Carjacking. Class 1 felony with a prison sentence between 4 and 15 years and a fine up to $25,000. Aggravated carjacking. Stealing a car from a vulnerable individual or while using a weapon. Class X felony with prison sentence up to 60 years, depending on the circumstances. Federal crimes lawyer, Chicago, Illinois. Facing a federal criminal charge in Chicago is as serious as it gets. Federal offenses are the most severe cases we handle at Combs Waterkotte. While state charges are serious, federal cases involve U.S. attorneys, well-staffed federal agencies, and harsh mandatory sentencing guidelines. A conviction can easily mean decades in federal prison, along with huge fines and lifelong consequences. If you're facing a federal charge, you need a defense team that understands the complexities of the federal criminal code. The Chicago, Illinois defense attorneys at Combs Waterkotte have plenty of experience defending clients in federal court. We handle pre-indictment investigations, negotiations with federal prosecutors, and fighting federal charges at trial. We work diligently to challenge the government's evidence, protect your rights, and pursue the best outcome possible in your case. Here are some of the most common federal charges we help defend against in Chicago, Illinois. Federal felonies. These include high-level offenses that fall under federal jurisdiction and typically involve interstate commerce, federal agencies, and federal property. Federal homicide. This involves homicides that occur in a federally controlled location, victims who were federal officials or employees, or deaths tied to another federal crime. Federal sex crimes, federal sex offenses, include those that cross state lines, use the internet or social media, use the mail or other interstate services, or occur on federal property. Federal conspiracy. These charges consist of federal criminal violations between 2 or more people with criminal intent who commit at least one action, an overt act, to advance the conspiracy. Federal drug crimes. Federal drug crimes are typically levied against individuals alleged to be operating large networks of controlled substance operations across state lines. Other common federal criminal charges we defend Chicago and Cook County residents against include federal kidnapping, federal RICO charges, federal white-collar crimes, federal drug charges, federal hate crimes, federal embezzlement, federal human trafficking, federal drug trafficking, federal weapons and firearm offenses, federal money laundering, federal securities and investment fraud, federal bank fraud, federal identity theft and fraud, federal check and credit card fraud, federal terrorism charges, federal misdemeanors, federal exploitation of a child, federal internet, computer, and cyber crimes. Chicago, Illinois. Criminal defense. Lawyer. Frequently asked questions. When you serve as many clients across as many practice areas as we do, you tend to run into some frequently asked questions. It's natural to want to know how your case is going to progress, what the potential punishments for your charge could be, and how we as a criminal defense firm handle each step of your case. The following are some of the questions we hear most often from the Cook County and Chicago, Illinois clients we serve. What happens after an arrest in Chicago? After an arrest in Chicago, here's what you can expect the process to look like. Booking and processing. The individual will be taken into custody by police, who may take fingerprints, photograph the individual, mugshot, check for warrants, and confiscate personal belongings. Interrogations or statements. After an arrest, law enforcement may try to question you. Just remember that you have the right to remain silent, and you have the right to have an attorney present. Prosecutor review. Chicago prosecutors will review your case to determine whether or not there is sufficient evidence to file formal criminal charges against you. Detention hearing. Within 48 hours, a judge will decide whether you'll be released on bail or remain in custody based on the seriousness of your charges, your criminal history, or whether or not you're a flight risk or a risk to public safety. Arraignment. This is usually the first formal court appearance in which you're formally informed of charges. You enter a plea, guilty or not guilty, and future court dates are set. Pretrial phase. During this time, the prosecution and the defense prepare their cases, reviewing evidence, interviewing witnesses, and discussing plea negotiations or alternative resolutions. Trial. If your case goes to trial, you may face a jury trial or a bench trial, with only a judge presiding. Trials can go on for multiple days or weeks, and they end, in most cases, with either a guilty or not guilty verdict. What should I look for in a Chicago criminal defense lawyer? When you're looking for a criminal attorney in Chicago, ensure they have a deep knowledge of Illinois criminal law. Ask if they've practiced in local Chicago courts and about their access to investigative resources in Chicago or Cook County. You should also look into their track record of case results, whether or not their firm has trial experience, and any online reviews of the lawyer or their firm. Can criminal charges be dropped in Chicago? Yes, criminal charges can be dropped in Chicago. It's important to understand, though, that the alleged victim cannot drop the charges. That decision is up to the authorities. Charges are commonly dropped in Cook County due to evidence issues, problems with witnesses, or plea agreements in lieu of a trial. What's the difference between a felony and a misdemeanor in Chicago? In general, misdemeanor charges are relatively minor, resulting in small fines or periods of probation, or, at worst, a few months in jail. Felonies, on the other hand, arise from serious criminal offenses and can result in years, if not decades, behind bars. How much prison time do you face for a felony in Chicago? The prison time a defendant faces for a felony charge in Chicago depends on which class of felony they were charged with. A Class 10 felony prison sentence ranges from 6 to 60 years. A Class 1 felony prison sentence ranges from 4 to 30 years. A Class 2 felony prison sentence ranges from 3 to 14 years. A Class 3 felony prison sentence ranges from 2 to 10 years. A Class 4 felony prison sentences ranges from 1 to 6 years. What are the long-term consequences of a felony conviction in Chicago? If you're convicted of a felony in Chicago, you will likely face a lengthy prison sentence and fines that can number in the tens or even hundreds of thousands of dollars. On top of that, you may also face employment barriers, housing issues, problems with professional licenses, the loss of firearm rights, and custody problems if you have children. What are the penalties for criminal sexual assault in Chicago? Prosecutors in Cook County and Chicago take criminal sexual assault, Illinois's version of a rape statute, very seriously. Depending on the factors of the case, including whether or not the alleged victim was underage or whether a weapon was used during the assault, a criminal sexual assault conviction in Chicago is either a Class 1 or Class 10 felony with prison sentences between 4 and 60 years to life and a fine up to $25,000. When do I have to register as a sex offender in Chicago? Convictions for certain sex offenses in Chicago, Illinois result in the requirement to register as a sex offender. Many charges require sex offender registration, but some of the most common include criminal sexual assault, criminal sexual abuse, sex crimes against minors. Can a domestic violence victim drop the charges in Chicago? No, domestic violence victims cannot drop charges in Illinois. The state has the ultimate say in whether or not charges against an individual are dropped. However, if the alleged victim wants the domestic violence charges to be dropped or they take back their accusation, that can bode well for a criminal offense. What counts as domestic battery in Chicago? In Chicago, Illinois, battery covers what would typically be charged as assault with a key difference. The offense must have been committed against a family or household member, like a spouse, child, parent, in-law, or roommate, within the home. What are the defenses to a domestic violence charge in Chicago? There are several defense strategies a criminal defense lawyer can use to fight back against domestic violence charges in Chicago, Illinois. Some of the most common include proving false accusations, asserting a lack of evidence, claiming self-defense on the part of the defendant, proving the defendant was defending others, demonstrating a lack of intent, showing mutual combat was involved. How do you beat a DUI charge in Chicago? In Chicago or Cook County, a DUI defense lawyer can help you get a DUI charge reduced or dismissed by proving procedural errors by law enforcement, challenging the admissibility of blood and breath tests, demonstrating a rising blood alcohol defense, showing that you were pulled over unlawfully. Can I get a hardship license? After a DUI in Chicago, while it's not always a guarantee, you can get a hardship license for a Chicago DUI offense. A restricted driving permit, RDP, may be granted if you need to drive for work, school, medical care, or to recovery meetings. You may also have to install a breath alcohol ignition interlock device, BAIID, on your vehicle to be eligible. What are the penalties for drug possession in Chicago? Penalties for drug possession in Chicago depend largely on the amount and type of the substance in question. Common substances for which Cook County residents face possession charges include cannabis, heroin, cocaine, morphine, LSD, and methamphetamine. Depending on the weight of the controlled substance you're alleged to possess, you could face a Class C, B, or A misdemeanor, or a Class 4, 3, 2, or 1 felony, and face as low as a couple of weeks in jail to 15 or more years in prison. Common criminal defense strategies for Chicago, Illinois charges. When you're charged with a crime in Chicago or Cook County, no matter what the charge is, prosecutors have to prove it beyond a reasonable doubt in court. A good defense attorney's job is to raise doubt about your involvement in the offense, and there are several ways to do that. At Combs Waterkotte, we've developed a number of proven criminal defense strategies over the years that we've used to help save our clients from over 1 million days in jail and counting. Here are some of the defenses we've found to be most effective in Chicago courts. Alibi. In this defense, we prove you were elsewhere when the crime was committed, making your involvement impossible. We use credible eyewitnesses, time-stamped records, GPS data, and surveillance footage to help prove an alibi defense. Consent. The consent defense hinges on the fact that the alleged victim consented to the conduct in question. It's most commonly used in assault and battery, sex offense, and property and theft-related cases. Defense of others. To argue defense of others, we demonstrate that your actions were justified to prevent imminent harm to someone else, like intervening in a bar fight, using physical force to stop a domestic violence offense, or striking someone who is actively harming a child. Duress. In a duress defense, we argue that committing a criminal act was your only reasonable option under the threat of serious harm. If, for instance, you were forced to drive a getaway vehicle at gunpoint after a robbery, we can argue you were acting under duress. Entrapment. Entrapment occurs when law enforcement entices or encourages someone to commit a crime they wouldn't have otherwise committed. If police persuade you into a drug buy or to solicit a prostitute, an entrapment defense may apply. Lack of intent. So many Illinois crimes require a defendant to act knowingly or with intent. If we can prove no intent was involved, we can often get charges reduced or thrown out. For instance, if you steal property you legitimately believed was yours, there was no intent, which may serve to reduce or dismiss theft charges. Miranda rights violations. If you're arrested in Chicago, police must read you your Miranda rights. If they do not, any statements you make might be thrown out, possibly crippling vital evidence of their charges against you. Fourth Amendment violations. Under the Constitution, you have the right not to be subject to unreasonable searches and seizures. If police gather evidence from your home without probable cause or a search warrant, that's a violation of your Fourth Amendment rights, and any evidence they gather may be thrown out. Fifth Amendment violations. The Fifth Amendment protects you from self-incrimination. If, through improper procedure or without an attorney present, after you request one, police solicit damaging statements from you, those statements may be disallowed in court due to Fifth Amendment violations. Necessity. If your actions caused you to make a split-second decision to protect yourself or another in an emergency, we may be able to argue a necessity defense. This applies in cases like driving someone to a hospital without a license when they're having a medical emergency or trespassing on private property to escape an immediate threat. Self-defense. If you assault someone when you have a reasonable belief of an immediate threat, we may be able to assert self-defense. Illinois law requires a proportional response to neutralizing a threatening situation. As long as your response wasn't over the top or egregiously violent, this may prove a key strategy in your defense. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.